investor and a member of Angel Investor Forum here in the Fairfield County area. Originally how I first crossed paths with Doug. And through my work there and also here as the legal advisor to the annual Fairfield University Startup Program and Competition, I have begun interacting and mentoring quite a few startups and entrepreneurs, particularly in this IP area, both through the startup program here and a couple of other incubators and accelerator programs in the Connecticut area. So I've come to grasp some of the issues particular to entrepreneurs and startups with respect to IP, particularly patents. And also I've kind of started to formulate some practical strategies for those particular types of entities dealing with the patent system. Because as some of you are clearly somewhat acclimated or aware of the functioning of the patent system, it's generally tailored towards larger entities, larger companies. So it can be a bit daunting and a bit disadvantageous for solo practitioners or solo entrepreneurs or startups to navigate their way through the system. But I feel like there are some pathways that may be even particularly advantageous to these smaller entities. So I have kind of formulated, like I said, a number of ways to bootstrap some of the tasks involved in obtaining patent protection and IP protection more generally. And so I don't have slides prepared. I like to just, I'll track this sheet that we have here. And also how I like to do these talks is if you have a question, we won't wait to the end. If you have a question that's topical to the point of discussion, just fire away. I'll call it out, and we're recording this, so I'll read it out loud again, so everyone can get a grasp, and we'll keep it moving from there. So when thinking as an entrepreneur startup about potentially protecting or doing anything with an innovation you might have, the first couple of key threshold questions that I think would be appropriate to ask yourselves is one from a defensive perspective and one from an offensive perspective. So defensively, you have an innovation, whether we had a blockchain project going over here, we have the plumbing part and computer aspects here. You have this innovation. One of the very first questions you should ask if you plan on developing it to any extent is, if I use, make, sell any of the above with this innovation, am I opening myself up to a lawsuit merely by using it or bringing it to market? So from an IP perspective, essentially, the framework of that question is, does someone else already have legal protection of this idea or this innovation? Because it can be, especially for smaller entities and entrepreneurs, it can be, this can be a step that can be skipped. You have this aha moment, you have an innovation, perhaps you've been tinkering away at it for a while, you finally have a breakthrough or some kind of development that you're excited about. It's certainly easy to just hit the pavement and start going with it. But you could essentially be walking into a morass of legal issues if this idea is already in existence and legally protected by some other entity. So the task that can be carried out to kind of assess and manage this initial risk is what's called a freedom to operate search, which is exactly what it sounds like. You're looking through the realm strictly of patents to see if there's a patent or published patent application out there that might run dangerously close to the innovation you have. And so this is a particularly good bootstrap area because one, this is a highly variable task. If you went to a patent attorney, this is almost certainly going to be an hourly rate task, which opens you up to cost uncertainty and potentially some time uncertainty there. So depending on the technology area of your innovation, how crowded or not crowded that particular industry is, these types of searches can range from kind of very quick wipeout searches to very intricate, complicated, nuanced searches that take a considerable amount of time. So outside of being highly variable, they also come with the risk of not being 100% foolproof, like any searching task would be. So this is an area I always advise entrepreneurs and startups to at least kick the tires initially themselves. Essentially how you would do this, how you would search patent rights to see if there's existing patent rights that might overlap with the innovation that you're trying to protect, is at least in the US, you can go to the US Patent and Trademark Office website. I've included the link here. And it's a fairly straightforward database to use. This is a fairly sophisticated group. It's pretty much Boolean search, keywords, those type of things. So you can navigate through the databases for issued patents and published applications and just kind of get a sense of what's out there. Again, you're not going to be able to turn over every rock. But then again, if you went to an attorney, they'll certainly turn over more rocks than you could. But based on the keywords you used, the timing of a third party's application being filed, you're not even guaranteed to get 100% foolproof coverage there either. So it's a simple database, publicly available. It's a relatively straightforward first step for a non-lawyer entrepreneur startup entity to take themselves, just to kind of get a lay of the land. And you'll want to sprinkle in synonyms and various keywords and all the things, if you guys are accustomed to doing any kind of garden variety database searching, same kind of practices would apply here. And so that's one area where you can potentially save yourself some money, and also kind of get a sense of if you might be walking into trouble, right? Either there might be an issued patent that's squarely on your innovation, so you might be avoiding an infringement lawsuit if you decide to move forward. And you also might be avoiding some unnecessary development or R&D costs if you need to keep going with the innovation on your end. And so that's a defensive aspect, upon the conception of your innovation. As far as the offensive steps, there's quite a few more. So in contrast to you protecting yourself from getting sued, on the offensive end, you want to take your innovation and determine whether or not you might be able to protect it as an asset or a competitive advantage in the marketplace. And so an initial task there would be a patentability search, which would be similar in nature to the freedom to operate search, except you'd be essentially widening the scope of your search. So instead of focusing merely on patented innovations, for a patentability search, you want to pretty much try to encompass the entire public domain. Because the quid pro quo for obtaining a patent from the federal government, in part relies on your innovation not already existing in the public domain. So you're going to have to look outside of just patents to other areas of public domain. Internet search engines, in addition to these patent office databases, and also just knowledge of whatever industry you're innovating in. Kind of identify the key players, scope out their websites. You could even potentially search under their names in the patent database. Anything to kind of narrow it in yourself. You might be in a particularly good position to tailor this type of search given your expertise in the field of endeavor you're in.
I've got a question.
Certainly.
So seeing how basically all technology is just built off existing technology, you come up with your innovation by seeing what else is out there in the marketplace and coming up with some novel spin or piecing together things. How are they really, when you just search the public domain, how are they making that? So is the patent office going to look at that and then how do they decide okay, this is novel and this is already existing in the public domain?
Well, they'll attempt to determine if something's novel. It's just essentially if they have exhausted their searching resources. So if you do get to the point where you file a patent application and it's before an examiner, the examiner is tasked with conducting a search of the entire public domain. So they'll examine, and we'll get to this a little bit later on, each and every aspect of your written claims, which is a section of your application, against all their known resources. Databases, they'll do journal searches, they'll do garden variety search engine searches. And so they are tasked with finding each and every element of your written claims out there somewhere. So they're not taking a gist approach, right? They're not going to say, like, oh, this invention's related generally to blockchain technology. So I'll just find any blockchain application and use it to form a rejection. It's much more granular than that. So they would be searching for each of the specific nuances that you've explicitly detailed in your claims.
Conducting the preliminary search in the public domain informs you as to what you can claim versus what you can't.
It's a good roadmap, yes. Yes, sir.
There's what you can claim and what you have the right to use is a different thing.
Correct. So, and I spent a couple of classes on this in my course here in the School of Engineering. The kind of the dance between right to use versus what you can patent. It's all about the scope of the search field, right? So let's say you invent like a new kind of chair, right? And you search the patent office databases, and I'm sure there's plenty of patents on chairs, but they're probably all long expired, right? So let's say there's no active patents that you find in your freedom to operate search that covers this new chair that you've come up with. So you feel pretty good about bringing it to market and not getting sued by someone for patent infringement. But let's say you do a Google search or check out a bunch of product catalogs for some competitors in that space, and you find a few kind of spot-on matches to your chair. That doesn't mean you can't bring it to market. You'd be a competitor at that point. But the existence of the same chair in the public domain would very likely preclude your ability to patent that innovation. So you could use it because you wouldn't be infringing on someone's patent rights, but you couldn't necessarily gain your own patent rights because it already exists in the public.
But if they invented it first, can't they just later on patent it?
Not necessarily. So in the U.S. there's a 1-year grace period where you have to file your patent application after the invention's been made public, or you're precluded from doing so. And in lots of foreign jurisdictions, there's no such grace period at all. So once it's public.
Making it public is when you submit it, right? You can't do what you used to do, which is mail it to yourself or something or date it somehow. Now you have to submit it for provisional patent, and then they give you a year to update it.
That'll be a good segue to one of our later segments around provisional patents. But that would be kind of constructively making it public. But doing things that would be more potentially prejudicial would be, let's go back to our chair example. Let's say you brought it to a trade show to show it off and to gauge market interest. If you hadn't done any patent work at that point, and the trade show was the first time your chair prototype had left the confines of your private garage, let's say, from that date of the trade show, you would have 1 year to file a patent application of some kind, or you would be precluded from doing so. So let's say, going back to your example here there's these other chairs on the market. If they've been on the market for over a year, or not even on the market, if they wrote it up in a catalog or some kind of a journal, anything that had the innovation reach the public is generally deemed a publication. So from that date, the clock starts, and they'd have 1 year in the U.S. So, because not every innovation is going to be, is going to be moved to patent. There are various strategies for people choosing to patent or not patent certain innovations. So if something's out there, the clock starts, and you have 1 year, and it's going to work the same for a competitor.
Do they consider presentations as a public disclosure?
Generally, yes. I say this. The safe rule of thumb is if you're divulging any meaningful details about the innovation to a third party who's not under some contractually obligated state of secrecy, then
Yes.
it would be deemed public. Yeah. So that is a particular problem area for startups and entrepreneurs. Larger companies oftentimes have policies in place and procedures to guide their inventors and engineers to the legal department before they run off and submit things to journals and present at conferences and things like that. But a startup without a big patent portfolio or a legal department, may not have the same provisions in place, and they might be excited to simply get their innovation out there in the public to gauge interest and potentially develop interest. So the timing is always a key factor. Generally, in the patent world, time is not your friend. So the quicker you can get something filed, the safer you'll be, and also the kind of earlier you'll have your place in line if someone were to go and invent essentially the same thing. Yes, sir.
I would just add that a lot of times early on like that, where you're showing your innovations to people you hope will invest. And so you have to be very careful to have NDAs in place with those people, because just talking to an angel investor is public disclosure. There's been no other.
No, absolutely. Pretty much just out of an abundance of caution, assume that telling anyone is a public disclosure.
Yeah.
It behooves you not to try to tease this rule out too finely. Just assume that it would start the clock. But in cases like that where you're trying to, you're out raising a round or some initial capital,
Couple of bucks.
yeah, you can often get investors to sign NDAs, but not always. Some of them won't, or some of them might tell you that they're not interested just based on the fact you're asking them to sign an NDA. And so there's ways around that, in that you can have these types of discussions perhaps without divulging the true points of novelty. Like if you say you're developing a blockchain application to deal with a specific problem, and say you just state the problem, without divulging exactly the intricacies of how you're solving that problem, you're not really publicizing or divulging the specific details of the invention. You're just kind of broad brushing. Here's the narrow universe within which the innovation operates, but you're not really giving up the secret sauce. So it's a bit of a fine line. I would always advise you to err on the side of caution. Do we say it?
Yeah, so Mickey, in all the time you've been at the Angel Investor Forum, has anybody tried to get the angels to sign an NDA prior to presentation?
No, not in my time there. We have not
Nor
been
in mine.
approached. Yeah, we have not been approached
Never
with
happens.
NDAs. Yeah.
And all the angels I talked to, 99% of them said they would not sign an NDA, because who can remember who told what when?
Yeah, and I mean, another reason that it might not be as appealing for me is that, it shows me that the company wouldn't have essentially tackled this initial IP task before rushing out to raise capital, which, again, none of these tasks are free, clearly, but as we'll get to later in the presentation, there's ways to be cost efficient about this, and get some of these ducks in a row before you go out to ask for the big bucks from angel investors. Yes, sir.
Why not just file the provisional and then go to the potential investors?
Yeah, that's that would be kind of my thought process if I was asked to sign an NDA.
Just file.
I would ask, in my mind, I'd be thinking, why, haven't they just taken that step? And that's one of the strategies I'll discuss later on, also.
But just to be clear, there's no way of protecting that other, or before that public disclosure. You used to be able to mail it to yourself or date it in some way as not being known to anybody but you. That's gone.
Yeah, I mean, if that was a practice, it certainly predates
Now,
me.
they changed that, I think, 2 years ago with the new patent law, where now it's public disclosure starts the clock. And you have to be able to show what you disclosed to whom and why to actually get that date.
You're saying first to file versus first to invent.
Yeah, exactly.
Oh, okay. So yeah, the first to file that changed a few years ago to line us up with most of the other jurisdictions on the globe. And again, it's a statutory provision that's largely geared towards larger companies who can file applications very quickly. So it tends to put entrepreneurs and smaller startups at a bit of a disadvantage, because they generally do not have, these types of intricate IP procedures and legal departments that they can just hand these off to. And
A lot of times they need to talk to other people
Mhm.
just to see if the thing works.
right,
And also there's a lot of communication required in order to get some synergy or something to happen. And you're not quite sure if that's the disclosure or not.
true. But the practice of mailing documentation to yourself, yeah, I would advise against that, certainly. Okay, so this is we've come up through the patentability search to kind of get a handle on whether or not your innovation might even be protectable from a patent standpoint. And it's same kind of caveats here with bootstrapping this. This is almost certainly going to be one of these hourly tasks if you go to an attorney, because it's highly variable. And they'll also probably tell you that it's not foolproof, which it obviously will not be. So this is another kind of easy, reasonable task for a moderately sophisticated entrepreneur startup to handle themselves. Between the patent office databases, internet searches, getting a handle on the main players in that particular industry, you can get a rough sense. So let's say you've moved past that and you're feeling reasonably confident about moving forward with an application. So there are a number of things that you can do to ready yourself for this task. Now, people file pro se applications. It's permitted. So you don't necessarily need to, by law, go to a patent attorney to have him or her file your patent application. And I'm, of course, naturally biased, but I would strongly recommend that you do so, unless you have experience in filing a bunch of these. I know I have worked with one of our fellow Angel Investor Forum members who's filed and prosecuted many patents on his own over the years, and so he's got a pretty good sense of what the task entails. But even then, it's not going to be your full-time job. This is a very niche area of the law. Yes, sir.
Is the fellow you're referring to skilled in the field of IP, or just a self-trained individual?
My understanding is it's the latter.
I see. Are you able to tell us who it is?
Yeah, let's see, why not? It's Eric Knight.
Oh, Eric.
So, and I actually recently worked with Eric on one of his pending applications that I think he just didn't have time to keep up with through the patent office. And the application was pretty good. And he filed it as a pro se.
What's the pro se?
For yourself.
Yeah, just by yourself without an attorney. But I mean, it's a difficult task to do. And so if you're serious about protecting your innovation, this would be, I think, a time that it would be wise to retain the services of a patent attorney. And so there are a number of tasks that you can tackle yourself ahead of time to kind of grease those wheels and also bring down your ultimate bill that you're going to be facing from the patent attorney. And again, these are all things that you're going to be in a good position to do as the inventor, as the technical expert in this particular area of industry, in order to kind of prepare substantively for a patent application. As we have noted here, describe the problem you're attempting to solve. Describe how to make and use the invention or the solution. Any drawings or diagrams that you can gin up that describe any of the componentry, any of the data flow, the process flow, is always useful. Pseudocode is a good thing to put in there also if it's relevant.
Sorry, what is it?
Pseudocode essentially, if it's some kind of a software application, and you have any pseudocode, essentially just a chunk of computer code that would be implementing whatever technique you're going to be carrying out via the software application. It's not always going to be applicable to every application. Like you probably don't have pseudocode in your plumbing application, probably not going to be in there.
So these days software is patented though, not copyrighted? I took a class a while back.
You can copyright it. Copyrights kind of vary in their value. Patenting a software-based innovation is going to potentially give you a much broader scope of protection.
The software has to be in some hardware that's implementing a solution to something. It can't be just software code. Something.
Yeah, and they'll have to copyright. Essentially, for someone to infringe your software copyright, they'd have to use the exact same code, which I'm sure would be not terribly difficult to design around a few bytes of the code. But yes, from a patenting perspective, I mean, software inventions do kind of take a beating a little bit in the courts, but they're absolutely still eligible for patent protection. I'm writing them every single day. So, yes, Doug.
Could you say a few words about how one goes about selecting a patent attorney?
Sure. Actually, we get to that a little bit later. So we'll get to that on the flip side once we tackle some of these, identifying the tasks that you can plausibly bootstrap yourself. So in this write-up section here, I mean, think of it kind of as a scientific journal. You don't need to worry yourself with legalese, because if you're going to bring this to someone, they'll handle those aspects of it. Describe the problem, describe exactly how you solve it from as technical a standpoint as you can. I always tell folks, especially when I do my legal advising here in the university startup program, and I'm in some of these college or university type incubator type situations, I'm constantly harping on the entrepreneurs to avoid adjectives when they're doing their write-ups. It's not a creative writing assignment. It's essentially a scientific document. So be very clear, concise, probably exactly how you think about it in your own mind when you're initially doing your brainstorming or your prototyping or those things. So the more substantive material you can put together on that front, the quicker you'll be able to get your patent application prepared and filed if you bring it to an attorney. Also, from a procedural standpoint, these bits of information I have noted here are things you're just going to need to have to file anyway, so it's good to compile these things ahead of time. Identifying the full names of all the inventors, residents, country of citizenship information. So here's another good reason to retain the services of a patent attorney, right? So let's say you are developing, a software application, and you're using, you're collaborating with, a freelancer, say in India or Brazil or something, and they've made non-trivial contributions to what ends up being the invention. So they're going to be listed as an inventor on this patent application. that creates a number of potential problems because most countries nowadays have laws on the books essentially requiring first look at any invention made by a resident of their country. These laws generally came out of a fear of kind of military or nuclear energy secrets being outsourced to other countries through the patent system. But nonetheless, these laws exist on almost all the countries' books, some of them with harsher penalties than others. So, India, for example, if you have a co-inventor who's in India, the Indian government is going to need to look at that application and essentially approve it for filing outside of India before you can actually file it in the U.S. So these are tasks that non-attorneys are probably not even going to think of, and even if they are vaguely aware that they might need to navigate these issues, figuring out how to do it and who to contact is going to be a separate hurdle in and of itself. So another good reason to actually retain the services of an attorney.
So does the U.S. have such a thing?
They definitely do, yeah. So it would apply, for instance, let's say you had a co-inventor, we'll stick with India, and for whatever reason you decided you wanted to file your application in India before the U.S. Maybe there's some commercial opportunities there. For whatever strategic decision, you want to file in India first. The U.S. government is going to require you by law to get essentially an okay from them before you can take this invention and file it initially in another country. So it's similar protocol in pretty much every country. Some of the countries are only concerned with, like I said, military or particular energy type inventions. And what generally happens is they have some review board or panel at the federal level. They'll read it to make sure there's nothing treacherous in there. And then they'll approve it. They'll send you a notice. It says you're approved to file this in another country.
So that international patent application that they have, so that even with that, you still need to get something approved beforehand? Like
It
you
would.
need to get approved that you can have this tech transfer to other countries?
Yeah, depending on the country. And it's...
Because I know they have that like big one that, I don't know, it's all in Europe, and there's one that's like all
Right.
the world.
But it depends where the inventors are from, right? So
Okay.
if you're in the U.S. and all of your co-inventors are U.S. residents,
Yeah.
you can file in the U.S. Without having to get the preemptive okay from any government jurisdiction. But if you're so essentially think of it from the U.S. perspective. If you're the U.S. federal government and you have U.S. residents who are developing technologies that can be used in some weapons system, and they, for commercial reasons or others, want to get this invention protected, in say China, right? Big market, large military, potential customer. They want to protect it so nobody beats them to the punch over there. And let's say they have a buyer lined up over there before they even start to commercialize it in the U.S. U.S. government is not going to be particularly enthused about you taking this potential, weapons technology directly over to China before they've even gotten a chance to see if it's something they might not want you to send over there.
I guess what I'm asking is if it's not some national security issue, do you have to check with them first?
It depends on the country. Some countries only require you to check with them if it's in a specific area, like military stuff. Other countries want to check all of them, regardless of the subject matter.
I'm sorry. That brings up two related questions. One with timing and two with, I guess, discovery/enforcement. So patents aren't quick. Having somebody read every potential patent where you could have a global collaborator, which today is probably everybody.
It's often, yes.
Yeah, and then the other one is, say you don't know if you are not aware of the rule and you somehow file in a foreign country first,
how do they discover it, / what do they do about enforcing it? Because I can imagine that there's a lot of people that also don't know the rule.
Yeah, that is a good question. And I've actually, and I've done fairly diligent research on this. I have not come across very many stories of enforcement. So it is, I'll call it unlikely, right, that you'd get pinched on this, but as a lawyer, I'm not gonna tell you to just ignore it, because and some of these statutes have scary sounding penalties attached to them, like jail time and fines and all this other stuff. So,
And then any ballpark on how long, because a patent, they have that whole dashboard with the needles telling you it takes infinity time if you file today. How long, it's essentially has to be the same amount of rigor for, can I release this?
no, it's a much lower granularity of review. So essentially, even the countries that do not have stated subject matter areas that they're concerned about, they probably informally have subject matter areas that they're concerned about. So they will essentially just quickly read through the document once to make sure that this isn't directed to some problem area that they want to keep in-house. So generally speaking, as far as the timeline goes, it's a couple of weeks.
Oh.
So, but that can still be a problem.
But it's not a couple of years.
No.
Very different.
Yeah,
scenarios.
no, it's the level of review is considerably lesser than when it's looked at by an actual patent examiner and they're searching prior art in various capacities. So from that relative point of view, it's a quick process. But sometimes if let's say you went to your trade show with your somehow novel chair 11 months ago, and you need to file your application or lose your rights in 1 month, a couple of weeks is putting you pretty close to danger zone. So
I do, and just as a data point, I do know a number of patents that have been applied for and in fact been issued in the U.S. where one or two of the people were U.S. residents, and another person would be German resident, and another would be somewhere else. And the patent office seems to don't have any rules about where the people live. If you apply it that and you want a patent in the U.S., they accept people from all over the place. I guess there's a look to see if it's dangerous or a weapon of mass destruction, but in general, they don't seem to have anything that restricts that I've noticed.
no, well, see
People
the
got patents like that.
in your hypothetical there, where you've got some U.S. inventors and let's say a German inventor.
He lives in Germany.
The U.S.
He
Patent Office.
participated.
U.S. Patent Office definitely doesn't care.
Right.
It's the German government that in this case would probably care, especially if there had been no previous patent application in Germany filed on this technology.
Usually they get the U.S. and then
Right,
they
yeah,
go on
exactly.
to other places if they think it's worthwhile.
But in that situation, the German government, I think they have defined subject matter areas that they're concerned about. But let's say it fell into like a military aspect.
Yeah.
You would be required by law, and again, enforcement is not terribly common from what I see, but
Yeah.
according to the laws, you'd have to go to the German government and say, hey, here's this application we want to file in the U.S. It was invented partially by a German resident. Give us a license. You'd obtain a license from them. They would say, hey, this passes muster. You can go ahead and file it in the U.S. without having to do anything here. So
It's very common with the way people
Yeah.
work and collaborative all over the place.
extremely common.
So where can we go to learn more about that process where you basically petition the government in some capacity to let you file this?
Well, you can. Well, what precisely would you be interested in learning?
How to run through that process? If just to understand how it works, who you have to speak to, what forms are used.
Generally in these situations, you'd work through an intermediary, which would almost certainly be a law firm in whatever country you need approvals from.
So there are no websites or books.
The WIPO is an international intellectual property organization that they have a pretty good rundown of what countries require what. But I mean, they probably don't have. I doubt they'd have a listing of like practitioners that you could automatically phone up in these various or email in these various countries to get to the bottom of it. But I could be wrong. Yes, sir.
So I have to teach students who are sometimes not U.S. citizens. They're from India. And according to Section 39, residents of India are not to apply for patents outside of India without prior permission. So does that mean my students can't really apply for a patent in the United States without first getting permission from the Indian government if they're Indian residents studying in this country?
No, because that resident is the kind of the key.
Well, Indian
turn of the
citizens
screw, right.
who are here on student visa, right? They're
Those would very likely be considered U.S. residents for the purposes of these statutes. So it's not a citizenship determination; it's a physical presence determination. Yeah. For most jurisdictions, I deal with India a lot, and that's generally how the India statute's viewed. There might be others. Countries who don't care.
There shouldn't be a problem with them returning to India and filing in India, even though they may have invented in this country.
Oh, that would be a problem.
If they have U.S. co-inventors, it'd be a problem for the U.S. people potentially.
It's an all-Indian team.
All Indian team, then.
They won
Yeah,
first place for the business plan competition for Connecticut.
If they invented it while they were
And they
kind of
invented
domiciled here in the U.S.,
Yeah.
then they might have problems.
Really? Right. So
That would be a very peculiar case study or fact pattern.
It's
Um,
complicated.
but yeah.
It's very
Sorry.
complicated.
Too specific.
Well, the other way sounds kind of funny too. If they invented it while they were resident here, it seems like the government would have said, you're too stupid to invent anything we care about. Go ahead and study abroad. You can't patent anything we would care about.
Well, to avoid getting too bogged down in the weeds on this, just view it from like a national security perspective. If you're a federal government who's providing the resources of roads and other public goods to people who are innovating within your borders, you want to make sure what they're innovating isn't going to be used against you by like a foreign power, right? So.
Well, they did the Facebook of Bollywood. I don't know if that's going to be used against them by the Russians or something. But it was relatively harmless,
Yeah.
I think.
It's Facebook and it's Bollywood. It's two separate countries, entities. Their residents here, the citizens in India.
Like I said, I've not read too many enforcement tales about these statutes, but that doesn't mean that these foreign governments might all of a sudden start cracking down on stuff.
The penalty, imprisonment for a term which may extend 2 years.
Yeah, no, some of these
at?
statutes are scary.
So how'd you find
What
that?
is
How
that?
can I find
This
that?
is what happens when
That's the India
students-
Patents Act.
The Section 439 makes punishable if you get a patent in contravention of Section 39, punishable with imprisonment for a term of 2 years and a fine, or both.
Wow. What is this that you're looking at?
This is patent in U.S. or India, where to file first. And I have these students who come from India and they study here, and they get these wonderful inventions that I help them to work on and all this other stuff in my
Listen.
class, and now they want to go patent.
Bottom dollar.
Where? They want to patent in India. They're Indian students. They study here.
Well, they can patent in India, but if they were
He says
here, it has to be reviewed by the U.S. because it was developed here.
Why don't you just have a patent here?
I mean, what I would do in that situation is probably just ask an Indian patent attorney, right, who's familiar with Indian law. So, and you probably get a reasonably concise answer.
Or just move to a country where there's no extradition treaty.
Yes.
Just go ahead.
Which one's
It reminds me of my college days. I asked a colleague when he knew he was packed. He said, "You put a suitcase in the middle of the room when it's full, you're packed." So just do it.
I have a question about something, about writing up the invention.
Sure.
So, sorry to change.
No, I think we've probably exhausted that topic.
So, every time I dealt with a patent attorney, they always ask for, what do you think is the inventive part of your invention, the innovation, or the novel part of your invention? And to write that up as concisely as possible, because sometimes you get people who write up, give you pages of code and all kinds of stuff, and you can't tell what's new in it.
Yeah, if you can identify clearly your secret sauce, that's definitely going to grease the wheels. That would be, that's a good kind of best practices habits. That's a good point.
But if I may, from a approach point of view, and this is what I've heard, having done this with the patent laws, that the first time you apply for this provision, it doesn't have to be a very professional, thorough patent application, right? The idea is to get it in quickly. You can use hand sketches. You can write your stuff up on a loose leaf piece of paper. You got that 1 year to make it professional, but you've got that year for protection.
That is, from a 30,000 foot view, that's accurate, but there's some major caveats in there that we'll get to here when we flip the page. Was there one in the back, way back?
Yeah, I did have one in the back. So I came in 15 minutes late because of traffic on the way over here, and I missed the first part of the presentation. So walking, I'm trying to get my bearing here. Is there like a PowerPoint presentation? Because I came in here, it's like it was Q&A. I'm cool with the Q&A. I'm just trying to figure out if the whole session is Q&A.
We've got essentially, I'm just tracking this handout. So I look at computer screens all day long.
Last month was my first month here, and there was a presentation last month, and it's just a little bit different than what I was expecting. So I'm just trying to get my bearing here.
While you're passing out, this thought that Doug brought up, he invented something 25 years ago for his thesis. And it was, he was 25 years early.
Okay.
So, if he would have patented it, he'd have nothing.
Well, I mean,
even though the technology was presented in his paper. So how do you prevent that when you come up with something that's breakthrough?
Well,
but nobody's ready to grasp it because they haven't taken the concept that far yet.
Well, that would be a kind of a commercialization issue, right? So even if Doug had protected his, like let's say he filed a patent application within 1 year of his thesis being published, he could have potentially protected whatever innovations were described in there. But I mean, just because you have a patent doesn't mean the market is going to want to commercialize the technology in there. So that's
because it could be mine is disruptive technology, but it's going to be a quantum leap in capability. And I've been saying the Israelis needed it last month, and they would buy it, but the U.S. isn't smart enough to grasp that.
Yeah. Well, it's probably less a legal issue than it's probably just more of a market adoption or acceptance issue. And at least if you go in there with a patent, if and when the marketplace does adopt the technology, then you've got an asset and some protection behind you.
So if you have a group of students and a professor or a couple of professors, and your goal is to invent things together, should you all sign an NDA with each other to avoid starting the clock, or is talking to each other already starting the clock? If you're not all co-inventors.
If you're not all co-inventors.
So say you're all working together on some subject area, two of them come up with some idea.
And then they come back to the group and share the details of. It's that could plausibly be deemed a public disclosure.
So it wouldn't be a bad idea to have the whole group say, "Well, we're working on this. We have this NDA."
Yeah, that'd be one precaution to take.
You could also make some kind of business arrangement where equity splits so that you don't want to.
That's probably a slightly more complicated solution to that problem, but yeah. All right, in the back now.
Alright, so,
Sure.
I'm designing a product and, I looked at the definition for, utility patents, that's what I'm really after for, the product that I'm coming out with. And, to understand the definition, it's really, I don't know, and you would know. So I thought about an analogy, how I would propose it to you, so that way I would protect what it is that I've got. And so, you got a car, right? Let's say, I don't really know about cars that much, so you got at all, really. So you got an engine in a car. I'm the guy that's coming out with a rotary engine, right? It's a different type of engine. At the end of the day, it's for a car, right? It starts a car, or it runs a car. So is a rotary engine, if a rotary engine comes in after a regular whatever, piston engine, is that a design patent or is that a utility patent? Because what I'm really trying to figure out is if I have a shot at a utility patent.
Well, are you aiming to protect the aesthetic or the function?
No, the function. The function, definitely.
Then you're talking about utility patent.
Okay.
So here's another example. Let's take like the iconic Coca-Cola bottle, right? So the view. Oh, there you go. So the look and the particular shape and the look of the bottle would be potentially design patent territory. Let's say they had some unique polymer that they used to actually make the bottle itself, would be utility patent territory.
That you needed in order to get that shape. That the innovation was this is the polymer that makes that shape.
Well, presumably you could make lots of other shapes with it too,
Yeah.
but yeah. So just think, design patent, it's the look, utility patent, it's the function. All right, we can briefly touch here on this trademark application item. I don't know if people are particularly interested in trademarks, but just to get a quick sense, unlike patents, obviously, which are going to be, methods, machines, compositions of matter, chemical compositions, articles of manufacture, things like that. Trademark, you're looking to protect a source identifier. Company name, brand name, a logo, tagline, something like those, to build a brand out. So just quickly to touch on these items that we've flagged here, and you can pepper questions if you'd like. But if you're going to go to an attorney to have a trademark application filed, here are some of just the basic things you want to pin down before you do, just to save time and money. If it's a text mark, exactly what we're talking about. Is it black and white? Is it in color? Is it a particular font? Is there some kind of stylized aspect to it? An image, same issue, black or white, color. Identify when you started using it, when you created it. Those types of details, just have them ready, because that'll save time, and they're all going to be things that you need for the application in any event. So,
Do startups, because branding is in my opinion, is a lot of value for successful startups. Do startups typically end up trying to trademark their brand or name?
Speak up a little bit louder.
he's asking if startups often opt to seek trademark protection for their company name or some of their brands or product lines. And yeah, they do. Unlike patents, it's not. Well, I shouldn't say it's not as time sensitive, but there's not a use it or lose it aspect, like where if your innovation on the patent side is made publicly known or available, you've got that year grace period. to file or you lose the opportunity. Trademarks, there's no such temporal limitations. You can plausibly file at any time. It's just a matter of whether or not someone else gets in there before you. So let's say
My question was, so startups do end up trademarking this stuff.
if they think that their brand has value, if they're looking to get acquired very quickly, and it's their talent, regardless of their offerings, like if it's just the people involved are attractive, like an acqui-hire type of situation, or if it's just the technology that can be easily inserted into a offering of some other acquiring company. Maybe the brand's not going to have a ton of value, but I'd say it's reasonably common. I'm sure most startups approach the venture thinking that they're going to build a brand, right? So whether it's company name, whether it's product name or a tagline or a logo, something to tie their product or service to them as the source provider in the mind of their consumers. All right, so that's kind of a rough sketch of some of the tasks that can plausibly be bootstrapped as entrepreneurs or startups. On the back side is some kind of cost considerations, right? Because that's always the key, one of the key aspects here as an entrepreneur, a solo, or a startup is, you're not always flush with cash. You don't have an operating budget like, a large tech company would. And so, you're looking to try to stretch your dollar, understandably so. Like I've noted before, I still think it behooves you to actually go out and retain a patent attorney. Now, there are some law school clinics that I think operate on a pro bono basis. UConn's is still in existence. Quinnipiac's, I believe, is no longer in existence. So there are those types of opportunities available, which come with the benefit, obviously, of greatly reduced costs. They probably still make you shell out for the government filing fees. I'm assuming they don't pick up the tab for you on that. But there's the downside is they probably don't have very much capacity. You're dealing with student and potentially academic, or even if they're being even if it's there's oversight provided by one of the professors, you're likely still dealing with an academic as opposed to someone out in private enterprise who's grinding away at this day in and day out.
I'm told they will file for you if you go through the patent clinic at UConn, but you will still be eligible for the micro-entity fees. So that means reduced fees for individuals who haven't filed more than 3 patents in their lifetime.
Micro-entity status require, there's a means test for that one also.
That's true.
So just as a quick aside, Doug's referring to, so when you file a patent or trademark application, you're obviously, if you're retaining a patent or trademark attorney, you're paying their fees for their professional services, but there's also fees that the government will levy just for the filing itself, kind of just administrative processing fees. So, and on the patent side, they come in different gradations. Kind of normal large entity status has higher fees. Small entity status, which would be like a startup or smaller, there's definitions as to how many people are involved and things like that. Small entities have smaller fees, and there's micro entity status, which is usually individuals who are below whatever means test and some other variables, and they pay very
Can it be companies too? Small companies?
It could be, yeah.
So if you start a small company with no actual income, then that
You
could
could qualify for the lowest
as a
fees.
micro-entity.
Yeah.
Which I've started many of.
What about a patent agent? What's the difference between a patent agent and a patent attorney?
For the tasks that we're talking about so far, substantively not much. Patent agents can't practice before a court, but they can practice before the U.S. Patent and Trademark Office. So for these kind of front-end tasks, right, obtaining patents, patent agents are permitted to do all of the same things that patent attorneys do. If it entered the arena of a court of law, patent attorney would have to sit that out. I mean, the patent agent, I'm sorry, would have to sit that out. Then you need to be a licensed attorney to practice in front of whatever state court or federal court you're going to. But that's a good question. So patent agents essentially are people who have passed the separate licensing exam administered by the U.S. Patent and Trademark Office. It's kind of like a second bar exam, but you don't have to be an attorney to take it. You just need a specific technical background. And then patent attorneys generally have all of the above. So, okay, so there are these law school clinics out there. There'll be some downsides to doing that. Like I said, turnaround time might be an issue. I'm sure the quality is reasonably good, but it's still going to be newish practitioners, students, and professors, versus hardened patent attorneys out in industry. So I would still likely recommend you seek out a patent attorney to handle these tasks for you. And in finding one or shopping around for one, as an entrepreneur or an early stage venture, I look for one that would agree to do a fixed fee arrangement for you. I mentioned in some of these earlier tasks, the searching tasks. I noted that those are almost always kind of hourly rate situations, largely due to the fact that they're so variable. You enter some search terms, you might get 100 outputs, you might get 10,000 outputs, right, from the Patent Office database. So it's going to be difficult for an attorney to preemptively tell you what one of those tasks is going to cost. But preparing and filing a patent application, they'll be able to give you a much better sense of what that costs because the confines of those tasks are much more static. So you should be able to go out and get a patent attorney to prepare and file your applications for a fixed fee, so you have some cost certainty and you don't end up arguing about unexpected costs on the back end. You'll also want to, before I move off of that, I have noticed in my work with a lot of the startups and early stage ventures, kind of through some of these mentoring things through the state, is there's often a lot of large firms, general practice firms, kind of brand name law firms that participate in a lot of these events. And they'll sponsor them, they'll send corporate IP attorneys to these startup events. And then I've heard from lots and lots of startups that when they approach these firms about potentially retaining them to do some legal work, they essentially get a response that just states the hourly rate that they offer, kind of take it or leave it. And so when I hear that, if you approach a firm, particularly a larger firm, that just says, hey, my hourly rate is $400 an hour, that's it. Could be one of two things. One, that could be a polite way for them to say no thank you. They might just not be interested in taking the work for a variety of reasons. And so they'll just throw out their large hourly rate hoping to politely shoo you away. Also, some of these larger firms have policies that might preclude them from getting creative with their fee structure. And so they might not be able to do so. So just something to keep in mind, because again, lawyers are service providers like any other service provider, right? So you're always going to want to look for some wiggle room to negotiate to kind of suit whatever specific needs you're looking for. So fixed fee, like I said, cost certainty. Everyone's on the same page. That's always a bonus. You'll want to ask to have that written up, and generally they refer to it as a retainer agreement before you really start substantive work on the task. You want to spell out exactly what the lawyer is going to do and exactly how much it's going to cost. Both parties sign it. Everyone knows exactly what's going on, so there won't be any kind of shenanigans or surprises on the back end for either side. Just as a peace of mind protected measure for all involved. I mean, lawyers are generally supposed to provide these things in any event, but you want to make sure they do. So then moving on to a topic that has been mentioned a few times here throughout the thing is provisional patent applications. A kind of neat little niche of patent law that I think can be particularly advantageous for startups and entrepreneurs. So a bit of background quickly. We've mentioned utility applications here on a number of occasions. Provisional patent applications are effectively placeholders for a subsequent utility application. So it would be for the same invention. You would just file it as a provisional, just a kind of a different designation with the patent office. That provisional application is not going to be examined. No patent examiner will pick it up. It'll just sit in their digital pile somewhere at the patent office. It'll be given a serial number and then it'll just sit there. And you have 1 year from the date of your provisional filing to file your utility application. They call it converting your provisional. So you have 1 year. If you don't convert or file your utility within that 1 year span, you're precluded from obtaining patent protection on that invention. So the benefits here, as I have noted, is filing a provisional is cheaper than filing a full-blown utility application. And then, like I noted, you get that 1 year to do lots of things.
And it's protected.
Right, so it is your place in line. But that comes with the following and very important caveat that I have noted here is, in order to keep that place in line from that earlier provisional filing date, everything that you'll ultimately want to protect in your utility has to draw support from that provisional application. So if you just wanted to get something on file quickly to get your place in line, and so you just slap like a title, the title of your invention, and a quick recitation of the problem you're solving, and just file it quickly, chances are the specific features, the specific technical aspects that you want to protect, you probably won't be able to use that earlier date to do so because there might not be any support for it in your provisional application. So the caveat with provisionals is you can plausibly just file them kind of as quick and dirty applications, but then you run the risk of them not being sufficiently detailed to support your subsequent utility application. Yes, sir.
I've heard this strategy of just throw everything provisional, everything you can think of. Forget about making the claims perfect. Just put everything, stuff that you wouldn't be able to necessarily patent. But this starts the clock for you, gets your placeholder, and then later you perfect it based on what you can actually patent.
I mean, as far as kind of rough strategies go, that's not a bad one, right? And provisional applications, the other difference and potential benefit is they don't actually require, you don't have to have claims in your provisional application, mainly because they're not going to be examined anyways. So you don't need to bother writing them. But yeah, that's a common strategy, is just any descriptive subject matter or materials you have, you just kind of dump it in, staple it together, and file that as a provisional. And then you can comb through it to see where all the useful bits are, in that year's time you have subsequent. The downside to doing something like that would essentially just be that you're, doing it too haphazardly and not including something that you really want in there. But if you're literally including everything that's to be relevant, then at least it's in there and you can draw from it. So that is a strategy.
So in that case, with that potential strategy, like, is there any point of having the lawyer help you with it?
No, I mean, if you're confident that everything's in there that you know to be relevant, then you could probably navigate filing a provisional.
Pro se.
Pro se, exactly. So yeah, so
But how do you spell that?
it's 2 words. Oh,
Is there any advantage to file a provisional if you could file a utility patent?
From a legal perspective, no, but there potentially could be some financial strategic benefits, which I'll outline here in the next strategy section. But that's a good question. If you have essentially a utility ready to go, from a legal standpoint, there's not really much use or purpose in filing it as a provisional.
Does it
So, yeah.
change the date at which the patent's length will expire? Does it give you an extra year?
No, because they will count the term. Your 20-year term will start from your effective filing date.
For the as soon as they get the provisional, that's the date that it has priority on, and it's also the date when the clock starts to tick. Is that right?
No.
It's the non-provisional.
Non-provisional.
You get an extra
Only the
year.
non-provisional. So then you're getting an extra year from the provisional.
Plausibly, if that might be of some use to you.
An extra year's a year.
Well, I guess it depends on the industry, though. You know, some things might be obsolete in 5.
While other things take a long time to monetize.
It's true.
Relate back to the provisional, non-provisional. The idea that everything in your full patent has to be supported by the provisional is understood. And so if you throw everything in the kitchen sink and you forget about it until one day after the year, you're done.
Yeah, you're toast at that point.
But if you do it the other way, if you just file the very vague one, and then you're like, ooh, I can do all this other stuff, that very vague one doesn't necessarily preclude you from filing a patent that wasn't supported anyway.
Correct, but you just wouldn't get the benefit of that earlier date.
Gotcha. That just to differentiate, if it was everything and you lost it by that day, then you're done. But if you do the vague thing, there would be no really point in doing the vague thing, but it hasn't precluded you from.
Right.
If you are one of those people who like 3x5 card done, yay,
Yeah.
and then you're like, well, I can do all of this, then your all of this is not necessarily boxed out.
Correct. If it's not supported or disclosed in that vague provisional, then
You can still.
yeah, you'd still be alive.
Wait, so what is that? So, it's an interesting thought experiment. So you're saying if we do throw everything out there, then you're saying we could never patent anything again in that area?
If you
Not that invention.
Okay.
You can start all over.
If you put everything in it
filing date
and you don't update it in time,
Yeah.
it becomes public and everything's in it,
It's not a
so.
provisional.
Well, provisionals technically do not get published.
But you can't file a patent in that area. If, say, you know you're going to be delayed for 2 years, then don't file as everything provisional. If it doesn't get examined, do they burn it after a year? So could you come back in 2, or would they be like, oh, nope, I remember you tried this thing once upon a time, we're going to check this to see
You
what
give it
it's
to
in."
Hillary. She takes care of it.
When you say technically not visible, so just talk about when it's visible to the public domain. In between a provisional, so have you as a patent attorney got access to what is provisional? Or is it
A provisional application is not going to be published by the Patent Office.
But
If
isn't
it
part of the file
becomes
wrapper of the examiner?
if it becomes part of if it leads to a utility application, then it can become part of that utility application's like file history. But in and of itself, just as standalone documents, provisional applications are not published by the Patent Office.
Even after the year is over and you fail to update it.
Correct.
I just wanted to make clear, if you file a provisional and you put everything in it, and then you wait 2 years, you can file another provisional or another utility application that covers the same stuff, as long as you kept your invention secret.
Yeah, you just can't use that earlier date.
Right.
Right, from the
You would get a new date.
So it doesn't stop you from trying to file the exact same thing.
As long as you keep it secret.
Or no one else.
Wait,
comes
what does
up
that
with it.
mean?
Right.
So filing the provisional is still keeping it secret.
Well, like I just said, the patent office doesn't publish provisional applications, so it's not considered an act of public disclosure.
They don't search them when they're looking for prior art.
Examiners, no.
Abandoned provisional patent applications are not searchable by the public.
No.
Yeah, so they're not public, you can't search them, that's it.
There's not a separate provisional application database out there.
But once you,
Can
once
we
you,
wrap things up, because we wanna finish maybe around 8:30.
Oh, sure.
Take an extra question or
Okay,
two.
so, well, let me just bounce off this deferred, because we had a question about whether it might be useful to do a provisional instead of a utility if you could. So, I've found working with startups and some entrepreneurs here who are very budget conscious, depending on where they are in their kind of life cycle. So one strategy that I've found to be somewhat productive for both sides essentially goes according to how I've mapped it out here. So you negotiate yourself a fixed fee with your attorney to prepare a utility application, file that utility as a provisional, and pay just some smaller portion of that agreed upon amount. And then pay the balance plus, some additional, minor additional amount at the point of converting to the full utility. And then lots of things can happen within that year's time, right? You can raise money, you can see if the marketplace is even going to, gravitate towards this innovation, find some licensing partners even. So if you're looking to defer the costs of filing a utility patent application, which is probably going to run you, anywhere in the 5, 6, 7, 8K range, generally speaking. So you can kind of work one of these arrangements where maybe you just, put down $800, $900, $1,000, file it as a provisional, pay the balance when you get to the utility stage and convert it. And then you kind of have that year to play with, and you can do a bunch of different strategic things in that time period. One other major caveat with if you're doing this pro se, right? If you file provisional pro se, you really don't want to forget that year anniversary date. That would be very problematic. So another benefit of using a professional patent attorney is they're not going to forget that date. That would be malpractice, right? So, and law firms all have electronic docketing system that send them, endless reminders about when certain things are due and all those things. So, but if you do decide to file one of these by yourself, let's say you do kitchen sink and just file it, make sure you know when that year date is and act on or make a decision one way or the other comfortably prior to that year date.
Yeah,
so you don't miss the boat.
I wanted to ask you that. So what is that sort of comfortability? So it's 1 year as long as you submit it to them through the electronic interface. So say this would be really less than ideal, but let's say things are crazy in your startup and you've got 2 weeks left and you just cram together something. It might not be, I guess I was going to say it might not be ideal. It might get rejected, but if anything, I don't know, that might be a good thing. If it gets accepted, then maybe you have got something accepted that wasn't really covering all your claims that you could have had. I don't know. What is there a real answer for this comfort period?
As far as let's say you're running out of time on your provisional clock and you need to submit your utility.
Yeah.
It'd certainly be better to just throw anything out there than do nothing and let the clock expire if you want to use that date.
Yeah.
Couldn't you just file for another provisional?
Yeah,
Another year?
I was just thinking of that. Just add the claims on another.
the date changes.
Another.
True. But you got some time.
The value of having an earlier filing date can be fairly immense.
Yeah.
I wouldn't just casually throw away the fact that you can just do another provisional. A lot can happen in a year's time, especially if you're in a crowded technology area. Lots of other people are probably trying to come up with ideas too.
Yep.
And they could have jumped in there in that year's time.
Yep.
So, I mean, it's of particular value to utilize the earliest filing date you can.
Yeah.
And so you can always, if you file a utility application, even if you're not particularly thrilled with, maybe you just roughly threw together some claims with your kitchen sink write-up, you can amend the claims during examination.
Okay.
So, and also quickly, this final point I have on here in the back, there's a couple of folks I know who actually have applications filed who are potentially nearing successful conclusions. I always tell folks to file a continuation application if they've received an allowance. You have to do it before you pay the issue fee. So you'll get a notice of allowance saying, "Hey, we've withdrawn all the rejections. We are going to be granting you an official U.S. patent once you pay some additional fees." So you would have to act before you actually pay those final fees. But I always advise folks to do it to keep an application alive, even if you don't immediately have like a different angle you want to cover, for a couple of key reasons. One, let's say you have a competitor who's eyeing your technology and they're monitoring your patent application or issued patent, which is not uncommon. So they look at your issued patent, they read your claims, they say, okay, this technology covers elements A, B, C, and D. It's successful in the marketplace. Like, we want to compete with this, but we don't want to get sued for patent infringement. So we will come out with a product that has elements A, B, C, and D prime. So it's technically different, not infringing, but it's going to be able to compete in this marketplace. If you have if you have an issued patent, you can no longer change the language in your claims. They're fixed, they're static. If you have an application that was still pending, you could play around with those claims and keep track of what your competitors are doing, change your claim language, essentially cover their new offering, and circle back around with them and say, hey, you're not infringing our issued patent, but we have this pending patent that's going through the patent office right now, and we've modified our claims to cover like your specific product offering. So it's a good defensive tool like that. And also, offensive, if you are an entity that potentially could be acquired, or even your IP, being bought or licensed outright, the people on the acquiring side are always going to like to have the ability to kind of potentially tweak claim language to their own preferences if they can. And if you're only dealing with issued patents, again, those are static assets that can't be changed. But if you have some pending applications that are still alive, an acquirer could be very appealed to jump on that as well, so they can maybe put a little tweak on it if they have a particular angle that they want to commercialize themselves.
So you can constantly tweak as the patent is in process of being examined. What are the fees for a tweak from the patent office?
It depends when you do it in the life cycle of the examination process. Sometimes there's no fees.
Sometimes it's just clarifications.
Yeah. So, but you at least have the ability to do so. Once it issues, I mean, it's great. You have an issued patent. That's good news. But you've officially put the fence around your scope of protection. So your competitors can look at it and try to design around and do all that sorts of things. So
how do you add that again?
it's essentially a separate application that is based off of your one that is succeeding through the patent office.
Same cost or what?
I mean, it'd be the same government filing fees, and if you were to go to an attorney, it'd be much less cost because they're not going to have to rewrite the whole application from scratch. They would just use the same application and probably write slightly different claims to go with it. So it's a pretty quick and inexpensive process.
That's protection.
Yeah, I mean, essentially it keeps open the possibility of you making additional modifications. Well,
how much longer does it extend the timeline?
it doesn't extend the timeline. It'll still, you can use the earlier, you can use the original filing date of the successful application, but you can't use it to add on to your term.
Well, I meant the sense that I would think that it gives you a a certain time frame of window to make any other changes you want.
Yeah, I mean, it's when you file it, the patent office is going to take, a year or so before they probably get around to looking at it. So it definitely buys you a non-trivial amount of time to kind of play around.
Okay.
Is there a reference for how to write a good provisional application? Like, if a lot of people sound like you're thinking of writing their own provisional, and other than kitchen sink advice,
Yeah.
is there like some good reference for?
The patent office website has pretty good tutorials, and they'll spell out like all the specific sections of what a patent application should have and what each of those sections should ideally cover. So that would be a good place. If you just go to USPTO.gov and do they have a bunch of tabs up there. If you just kind of tool around on their patent section, they have a lot of resources for kind of pro se folks and entrepreneurs and small entities.
One more thing.
Sure.
Can we make this
Let's
the
say
last
if
question?
I'm taking existing technology and I'm repurposing it for another industry altogether. Let's say like a retractable mechanism, right?
Mm-hmm.
Obviously, whoever designed the patent, utility patent, design patent for the retractable pen, it was protecting writing elements. But let's say I'm taking the concept and I'm transferring it to something totally different, unrelated, that doesn't compete. Is that something that you could also look to take things that already exist when I'm trying to protect the function of something else and file a utility patent?
Yeah, you can use known components to build a new, a novel sum of components. So yeah.
All right, well, I hope everyone will join me in thanking the speakers. After these presentations, sometimes people like to go out for a snack at one of the local diners, I think Penny's Diner. Is anybody interested in doing that? No? All right, it's a rainy night, I understand. Next meeting is going to be on the 28th. It'll be Madeline Hauptman, and she's going to present the Power Angle, a tennis racket which she's brought to market successfully. She's based in Brantford, and I hope you'll all be able to join me at that time. Thank you and drive safely.
The 28th of this month?
28th of November.
Okay.
November. Thank you.
Good session.
Hey,
Thanks for answering all the questions.
Yeah, if you have any others, feel free to just.
Yeah, do you have a card?
I do. I got a stack over here. Also, info's on here too.
Okay, just so I don't lose it.
Yeah, there's I put a bunch of that on the table.
That guy.
Yes, sir.
The final continuation, that's not a condition, is it? Doesn't it have to be, have attendant claims and everything? You can't say, I'm gonna file a continuation.
It's essentially a separate standalone application. It just.
But it is an application, it's only valid if you accompany it with a new set of claims.
Correct.
Okay, so it's not.
I mean, they'll take it if you put the exact same ones in there, but the patent office will reject it. I mean, they'll give you they'll allow you to file that. You'll just get a rejection that says, hey, this is the same thing.
But it's not like, all you have to do is file a continuation and you can come up with stuff later from the original patent.
Yeah, as long as it's supported in the original application, you can come up with new claims and new angles. And
I mean, if I don't know what I'm gonna do and I know the some claims will be rejected and everything else, I just file a continuation.
yeah, that's okay. You can just file one and leave it out there.
Or you can hang.
Yeah, I mean, you'll eventually get rejection and stuff that you'll have to act on, but you kind of at least start the clock again for you.
Okay.
Get a little bit of new life.
Enjoy it very much.
Thank you.
Bye-bye.
Yeah, Mickey, you got a card?
I do indeed. I think I got a stack of them over here on the
You
table.
didn't really
But that
mention
is your
everything.
number on the handout.
On the handout also, yes, it's the same info.
Real good, Mickey. Thank you.
So,
I don't know how you got
it was a
it.
good,
It seems
it was good. I also got to
small time entrepreneurial point of view that there's a
Thanks.
What are the-
I like the
down
what are
thirds.
the besides my preferred.
Well done.
life,
I've got your business
what
card,
are
so-
the different aspects of that?
All right, guys, thanks very much.
Anyway, there's kind of a role
Especially
for
when
you
you have
guys
because
for
after
transfer.
years.
That's true.
And you know, the Coca-Cola, right there.
It's all a matter of whether or not you can save
But you
it.
know, the big companies too,
recipe, right?
you know, if they want, if they've got really deep pockets, they can, I mean, they can either buy you out, or they can foil you, or they can go around you. You know, it's, I mean, there's certain ideas that are very, very unique, but they're just like the number of companies that, you know, end up becoming $1 billion company out of a garage or a committee. And,
I got a
you know,
curious story the other day, 'cause word came up on the.
I always sort of thought that if you want to be an inventor,